right, I think I am first up, and just want to say welcome everyone. Happy to be here. My name is Jamal Jordan. I am an intellectual property attorney. I work for Stinson LLP in St. Louis. My primary practice is in patent law. Kind of get into all of the distinctions there and what that means. But like I said, just looking forward to get started. I know we had a packed schedule, so I'm going to just get going. So if we could move to the next, probably to the next two slides. Okay, so, what is intellectual property? So typically when people think of property, they think of what lawyers understand to be real property, which are kind of the tangible things that you can hold, properties and land, buildings and things like that. But intellectual property is a bit different. That's your intangible properties that are really the creations of the intellect, hence intellectual property. So basically your intangible creations of the human mind. And we typically place those in these four buckets here. So patents, copyrights, trademarks, and trade secrets. Your intellectual property is going to typically fall in one of those four buckets, and you're going to be able to protect your intellectual property by using these, one of these four avenues. So I'll be talking primarily about patents and trade secrets and the kind of the dichotomy between those two, but I think it's important to at least briefly touch on copyrights and trademarks just so you can see where the intellectual property falls there. So really quickly, copyrights is really an exclusive legal right that has to do with things that are done by authors. So things that are printed, your published works, things you perform, your film and recorded arts, that's what falls under the copyright laws. So your music and your books, your plays, those are the things that you get copyrighted. Also, sometimes we'll see kind of the C in the circle, and right here at the bottom of the slide, right? Circle C, 2001 Eden. So this is copyright protected. So these are the types of things you get copyright protection. Trademark has to do with your name, right? So when you have a good or a service, you want to make sure that good or service falls back to your name, and other people can't trade on that name and take advantage of your goodwill. So the types of things that you get trademarked would be your name, a word, a phrase, a logo, symbols or pictures or images. And what they're doing is they're referring back to, like I said, your good or your service, and they're letting people know that good or service that mark represents this good or service. And if someone else were to come along and try to use that, you're able to protect yourself because you've registered and you have those rights to that name or that image or that logo based on your good or service. All right. So next slide. I think that kind of covers the four buckets. And like I said, I'm going to talk primarily about patents. So, usually patents is the name that most people will say when they say they want to protect their idea, right? I'm going to patent that. I'm going to patent that. So we talked about, there's a few others, but patents is really the big one. So what is a patent? All right, so we'll go to the next slide about what is a patent. So a patent is an exclusive right to make, use, or sell an invention. So a really good distinction here is, or a thing to point out is, a patent is really the exclusive right to exclude. And that right is given by the government to an inventor. And there's a trade-off. So you will get that exclusive right to exclude others from making or using or selling your invention for a period of time. 20 years is the period of time given for an invention that describes kind of how your invention works. And for that 20 years of exclusion, you need to provide a full disclosure of your invention and how it works, all of the key aspects of it, so that the public can benefit from that. And when your excluded rights are over, they can use that to make advancements. They can practice the invention themselves, and it really promotes the full inventive scope by allowing people to partake in your invention. So next slide. So I touched a little bit here, but yeah, so the whole concept here is to encourage development. So by providing that 20-year span where you can prevent others, you get the incentive of being able to capitalize on your invention. But the public gets the incentive of being able to see what your invention was, seeing how it was made, saying how so they can make it when your exclusion rights end, so that then they can then create improvements and therefore help the general public to increase the amount of disclosures and inventions that are out there. All right. Moving on to the next slide. So I just want to give a good example. So just so people can really see, what a patent looks like. So here's an Eaton patent. It's, not to a terribly complicated subject matter. It's a grating that can be used in railway cars or just anywhere someone might be walking or standing. But so you can see the first page has figures. Typically, you'll have figures with reference numbers on them, because what you need to do, like I said, you need to fully describe the invention. So you're going to describe how it looks, the shape, the orientation, how it works, what are the advantages. And so you usually refer back to numbers, numbered items on the figures. And that's how you step through the application to describe all the different aspects. So you can see this is a pretty simple concept, but there are many, many pages that went into describing kind of every intricate detail and why it was important and why it was different from what was previously, what was already invented, because that's really the key aspect. You want to tell that story of why my invention is so important and why it's different than what was out there before and what those advantages are. So go to the next slide there. So here's another Eaton patent, and I want to show you this one just so you can see kind of the key point or the key parts of a patent really fall at the end of the patent, which are your claims. So the claims are numbered long sentences where you're describing the different aspects of your invention, and you're getting really down, you're boiling it down to what's the key features and what makes it different from what's out there before. So this patent here, this is an application not yet matured into a patent yet, but it's an application to an operator for kind of extending through a circuit breaker box, where you can see the top there's a handle where you can turn the handle. There's a linkage that goes through the circuit breaker box, and then you can engage the circuit breaker through the engagement plate there on the end. So the claims step through each one of those parts. The key aspect really here is that plate there on the end that allows a little bit closer tolerance, so you get a better one-to-one movement between your actuator handle and the plate. But the claims really step through all those features, and you can see that it's numbered there with all the secondary features. And this is what is going to carve out the scope of your protection. So the claims there in the patent are very, very important. Okay. All right. So this is just real quickly, everyone understands Apple. The point here I want to make really is just that, you don't need these big grand ideas for a patent. It's really these small incremental changes that provide some benefit to a consumer or user or manufacturer, or what the case may be. And you want to protect that, because there's value in that, and being able to exclude others from doing that. So here, Apple, I don't think they actually implemented this in any of their iPhones, but there are these tabs that could deploy out to protect the screen when they fall. So these are the types of inventions that people and corporations, try to protect. All right. So I think it's also pretty important here to talk about, careers in patent law and kind of what the patent industry carves out as far as, how you can be involved in it. There's actually, it looks like there was one career that I actually got cut out. But so patent prosecutor is, like I said, is what I am. So a patent prosecutor is the person who files the patent application. So they work for the inventor, they draft the application, they get that whole patent document put together, and they file that application with the patent office. And they're the ones that argue back and forth with the patent office to try and hopefully eventually get a patent. And those are usually people who work at law firms or corporations. Now, a patent agent doesn't have to be a lawyer. So yeah, the distinction there between a patent prosecutor and a patent agent is a patent agent is typically a scientist and engineer who's very skilled in a particular technical expertise. And if they work at a law firm or a corporation, they will assist the attorneys in prosecuting patents, or they could actually work at the patent office and they would be the individuals who will receive the applications that are filed, and they're the ones that ultimately will determine, whether or not the inventor will be afforded a patent. And then kind of at the end of the patent process, once you have a patent, you might be a patent litigator. So they're the attorneys that will adjudicate any disputes. So if someone is asserting that another entity has infringed on their patent, the patent litigators are the ones that, come to the conclusion on, who's at fault, if anyone. So that was that. And then the last bucket, so we've talked about patents, we talked about copyrights and trademarks. The last bucket here are trade secrets. And trade secrets can be thought of as kind of the alternative to patents in a way to protect your inventions through trade secret. So you can move to the next slide there. Trade secrets have to do, and to the next one, have to do with, so with patent law, you were disclosing your invention. There was you got a benefit, you got that 20-year exclusivity rights because you disclosed your invention. Now with trade secrets, it's quite the opposite. The goal with trade secrets is if you have like a formula or a practice or a process that can't be easily either reverse engineered or figured out once it's been received, you may want to consider a trade secret, because if you can take the steps to keeping that invention secret from the public, limiting who has access to the formula, keeping it covered, things like that, then you can potentially keep those rights indefinitely, as long as you can keep it secret. So you can move to the next slide. The benefits there are very much similar to patent law, right? You want to incentivize someone you keep to have, to benefit off of their proprietary information. You're keeping it secret. You have to take steps to keep it secret. And by doing that, you can reap the economic benefits. And in the next slide, I think, right there. Yeah, these are just some common examples of, I think, trade secrets that people may not know they're trade secrets, but they're well-known trade secrets out in the public. Coca-Cola, the formula for Coca-Cola, the herbs and spices for Kentucky Fried Chicken, and whatever it is they put in Twinkies to make them taste so good. Those are all trade secrets that they, elected not to file for patent protection, but instead to keep it secret and reap their economic benefits that way. So that's all I have. I'm gonna hand it over to Ying to talk about the ways in which companies protect their ideas.
Thank you, Jamal. Hello, everyone. Thank you all for coming. My name is Ying Zhao. I'm the IP counsel of Eden Corporation. So I'm happy to be here. So I'm going to talk a little bit more about how do the companies generally protect their ideas. Next slide, please. So typically when we talk about the IP protection of ideas, in general, we'll think about a technical kind of ideas, whether you have a new product, you have a new technology, you build a new model, or those are kind of a typical ideas people come to think of when they think of IP protection. So that's true. Actually, we were typically for seeking patent protection, we were looking at the technical ideas, whether those satisfy the criteria for patent protection, we'll pursue that. But in addition to that, we also have other ideas within the corporate setting we probably wanted to protect as well, but not necessarily in the patent format. So, for example, the know-how, which is generally in the form of unpatentable inventions, the formula, manufacturing process, testing method, or assembly techniques. These are generally probably will not be able to get the patent protection on them, but typically they will play a significant role in terms of a competitive advantage for the company as compared to the competitors in the industry. Also, we have some strategic commercial ideas, which can be offer commercial value to the company as well. And also, if those are not being protected well, that will cause some loss to the companies. So typically speaking, I think the technical ideas generally will look at the patent to protect them. For the know-how, strategic commercial ideas, will typically, if possible, we'll use trade secret to protect them. Next slide, please. So why do companies care about patents? So basically the three reasons. One is we want to reward the inventors. So the inventors spend their time and effort in coming up with innovation or technology, then we wanted to seek a patent protection of them. It's a creating value for the company as well. We wanted to give the inventors incentive to continue to innovate, to generate ideas. Within Eden, I think we also have sort of a reward program. So if a technology or innovation being eventually we get a patent granted on them, the inventors will get some monetary reward as well. So the second reason why companies care about patents is that patent typically can offer you a very good competitive advantage. For example, once you have a patent on a certain technology, that will give you the right to exclude your competitors from that field created by that innovation. So that will give you the time to build a product, to go to the market, and to sell the product to the customers, while the competitors cannot do that. Even if the competitors wanted to get into that field, they have to design or run the patent claims you get from the patent office. So that will increase the cost, and also they will not necessarily will be successful in doing so. Or if competitors wanted to go into the field to compete, they probably wanted to get a license from you. Whether to grant that license, it's in the patent owner's discretion, and also at the same time, even if you grant the license to the other industry players, that will generate revenue streams just based on the license itself. Also, the patent portfolio can be a very important strategic asset to the company. So imagine if you have a technology, you get a patent on it, and then that technology become part of the industry standard. So then that means every player within the industry have to follow that standard in order to build their products. Now, in order to be able to use this, build a product according to the standard, they have to implement the technology you already get a patent on. Then, even though you probably cannot, prevent them from doing so because of certain rules regarding the standard related to the patent, but you can still, arrange a royalty payments with them. So that way, that will also be created as a sort of a very steady revenue streams. In the defensive kind of a setting, is that when a patent owner sues a company for patent infringement, if that company has certain patents within its own portfolio, that will cover the sort of a patent owner's products. Then the company can use that as a strategic asset to force the patent owner to come into a negotiation with them. Then they probably can enter into a cross-licensing arrangement instead of going to expensive or exhausting patent litigation. Next slide, please. So typically, for the patenting process in the corporate world, it includes generally 4 steps. The first step is once the engineer or company employees will formulate their ideas into a disclosure internally. So they will typically include the title, including the summary, and then they will describe what kind of problem has been solved by the idea they have, and then probably include a little history for the people to understand about the background of the invention. Once the invention disclosure has been submitted, like within Eden, we have a record system basically to store these invention disclosure. Once it's been submitted, and then it goes into the internal review and approval process. So I will use Eden as an example. For every business unit within Eden, will have its own sort of patent review committee. So once the invention disclosure has been submitted, the patent review committee will have review it. The invention disclosure, basically the criteria includes sort of a twofold. One is a technology differentiation. The second one will be commercialization prospect. So from the technology differentiation standpoint, they will look at whether this proposed invention disclosure includes ideas that actually significantly advance as compared to the existing technologies. That's sort of like counts as a technical kind of a criteria. If it doesn't improve based on the existing technology, or it's sort of like maybe minor improvements, it probably does not satisfy the criteria for going for a patent filing, because as we all know, the patent comes with a cost. So in order to justify the cost, the first criteria you need to meet is that you have to have enough technology advancement as compared to the existing ones. The second criteria is a basic commercialization prospect. So it's more like a cost benefit kind of analysis. So you pass the hurdle of the technology differentiation. Now the business will consider whether this patenting this technology will give the company enough benefits to justify the patenting cost. So typically the patent review committee will consider whether the technology can be used in the Eden product. If it does, then give them more incentive to file the patent. If the idea can be used in Eden product within the multiple platforms, that will even increase the value for them to approve the patent value. So after the internal review process, usually the decision will be made whether we will file a patent application on the certain event disclosure. Then the next step will become sort of like we will prepare a patent application, as Jamal described, in that format. So typically we can prepare the patent application in-house, or we can use send it to the outside law firm to help us to prepare the patent application. Once the patent application has been prepared, we will file it at the patent office. Then it will start the sort of a negotiation process, so-called the patent prosecution. Basically, the patent applicant will sort of negotiate with the patent office as to in order to get a patent granted. And now typically the examiner of the patent the patent office will conduct their own prior search, basically to find out whether the invention contained in the patent application has used that kind of satisfy the novelty or the non-obvious standard in order to get the patent granted. Usually in these days, especially in our industry, the examiner typically will come back with the office action, which will contain their decision and a reasoning on which patent claims in the patent application will be allowable, and some other claims probably will be rejected. And then the patent applicant to receive that office action, they will start the response process. Basically, they will formulate their position on whether to accept the allowed claims or whether they wanted to rebut the patent examiner's reasoning on rejection the patent claims. So you can go back and forth for a certain period of time. Eventually, they will reach the patent owner and a patent applicant and the patent office will reach an agreement on certain patent claims that will be, granted. Then you will have a patent. Next page, please.
Excuse me. We have a student who has a question.
Sure.
Nigel, you there?
Yeah, I'm here.
Okay.
So with the process, with the patent process, right? And then when you go to the whatever representative you said walks through you, it doesn't have to be a lawyer, but they have to be I forgot that term of their position. If you want to remind me real quick.
Examiner from the patent office?
Right. The examiner.
Okay, yeah.
So you're working with them to get your patent, and they go through this process, right, to make sure that it meets the standard to become a legal patent.
Mm-hmm.
So my question to you is it recommended that you would have a lawyer also as like a third party just in case the process goes smoothly, or you've never seen a situation as to where that wasn't necessary?
I think there's a different way to approach that. So typically, in a company, we will have in-house counsel. For example, me, we will if we decided to prosecute the patent ourselves, we will be the party to negotiate with the examiner at the patent office. Sometimes we will retain experts like Jamal Jordan as our representative to negotiate to negotiate with the patent examiner through that process. Sometimes in a small company or sort of individual inventors, they can actually file a patent application themselves, and then just even sort of like non-lawyers, they can also just participate in that process. There's really no requirement that you have to have a lawyer to represent you in that process. So anyone can pretty much do it. It's just more like if you are more familiar with patent law, you're more familiar with the procedures and of the patent office, then you probably have a better chance to get the patent granted in a short time. Does that answer your question?
Yeah, thank you.
Okay, sure. Any other question before we move to the next slide? Okay, we'll move to the next slide then. Okay, so as Jamal mentioned, I think there's two types of sort of usually seen kind of IP protection, the trade secret and the patent, particularly for the technical ideas, for the other know-how and strategic or commercial ideas. I think there's probably not a lot of discussion needed for as to in the strategic or commercial or know-how, those kind of areas is probably trade secret is the best format. But in the technical ideas that you probably, the company typically will have a calculation whether we wanted to take the trade secret to protect our idea, or we wanted to use more the patent to protect ourselves. So there are some calculations here listed. Basically, there's several factors you can consider. One is that if you have an idea regarding the product or process, whether that can be either reverse engineered. If that's the case, probably trade secret is not a good form for you to protect your idea. Because as Jamal mentioned, if it's a reverse engineered, then you lose that secrecy and the trade secret is gone forever. So pretty much in this kind of a situation, if you really wanted to protect your idea, patent is the way to go. The second factor is how likely can a patent be obtained? That you wanted to consider the subject matter and the novelty. So as I think in the recent jurisprudence of the patent law is that the subject matter become a sort of big issue. For example, if you have an abstract idea, you cannot get a patent protection. So that's sort of like you wanted to consider the idea you have, how abstract that is to decide whether that's a good candidate for patent protection, or you want to just keep it a secret if it's possible to remain the secrecy through your efforts. Or in a novelty kind of a criteria is that if your ideas is probably not that novel, maybe it's a slightly like improvement over the existing technology, it's very likely can be, even if not being rejected based on lack of novelty by the patent office, it probably will be rejected under the obviousness standard by the patent office. Then you probably wanted to consider, it's sort of like a cost and benefit kind of a analysis. Do you want to go through the prosecution process, spend tens of thousands of dollars to negotiate with the patent office? Even if you eventually get a patent, it will be super narrow. It's probably not worth too much to your company. That kind of calculation you need to perform in order to determine whether you wanted to file that patent. And also, another calculation you need to determine is that whether you patent an idea, even if you get it, can you actually enforce the patent? Sometimes, for example, if you have a manufacturing process, you wanted to get a patent. Your manufacturing process satisfy the novelty, non-obvious, all that kind of stringent standard of the patenting. Then you get it, but how are you going to enforce it? So, for example, if your competitor copies your idea, copies the manufacturing process, or come up with a manufacturing process independently, just exactly the same as yours, if you don't have access to their manufacturing facility, you probably will never find out. So that's sort of like a detection problem. Well, you have to consider that before you make the decision to go through the prosecution process. Because if you get a patent, you cannot enforce it. It's pretty much worthless to you, right? So lastly, the consideration is that what is a commercially valuable lifetime? So in different industries, the commercially valuable lifetimes probably will be different. For example, in our industry, typically, I will consider that the patent probably will be very, very useful for the first 10 years or 15 years. Then, getting a utility patent, it's very valuable for us to keep that invention or ideas protected against the competition. Now, if you are in the industry that the patents probably the commercial lifetime is much longer than that, then you probably don't want to. You need to seriously think about it whether you want to keep that idea if you can as a trade secret. Instead of sort of like, enter into that deal, basically getting a limited time of protection, and then you have to release the idea will be released into public domain. Everyone can use it to compete with you. So that's sort of like another consideration you wanted to take into account. I believe that's the end of my presentation. I will pass it to Dr. Groothy.
Take a small moment real quick and just give a verbal communication to the team. If there are any questions that you have, this is a wonderful opportunity for you to ask it. Please use the raise your hand feature if you would like to ask a question. Okay, I see a hand raised here. Mr. Nigel again.
I'm sorry, I might be asking a lot of questions tonight.
No, this is your opportunity to learn, man. Please ask your questions.
Okay, so you said during the process, you said about keeping the patent information secret. Like there's a certain paperwork for that. I thought is that what I heard?
No, I think it's either a trade secret or a patent. If you patent it, it's pretty much it will go into the public, so you can't.
Oh,
really
so
keep a,
okay.
Yeah.
So it's basically the same, but if you want to keep yourself secret, you would file a trade secret instead of a patent. So basically, a trade secret is a patent, but it's kept confidential.
I think the trade secret, you don't need to file it with anyone. So it's more like the trade secret protection is more like under the state law kind of a regime. So you don't really need to file with anyone, but if you keep it secret through your own reasonable efforts, you can keep it as long as it's secret. You can keep it that status. And if someone misappropriates your trade secret, you will have legal remedies through state law and also federal law recently passed in 2016, if I remember correctly. You can have some claims against them, but it's mainly different from the patent law. Patents is that you don't need to register the trade secret in order to get protection.
Okay, so it's just a protection over the patent. So you're gonna file the patent, but then also get a trade secret if you want it to remain confidential, or have protection over the patent, is what you're saying.
Yeah.
Okay, and then my second question is, after you get the patent is filed and you operating or whatever, and then you said something about filing for a utility down the line. Can you go over that again?
Yeah, that's a good catch. So basically, I think I was alluded to, in the patent world, we basically today we just talk about a high level, kind of a different, the IP protection form. Within patent protection, I think there's different types. So utility patent, typically in the US, there's 3 types of the patent protection: utility patent, and a design patent, and a plant patent. Utility patent generally protects sort of like the standard kind of patent, kind of technical solution you have. You can get a utility patent. Sometimes a design patent, you basically can protect the ornamental kind of appearance of a product. So the plant patent is basically protect a certain novelly created plants. So that's sort of what I'm referring to. But yeah, you heard it right. The utility patent is basically one of the most common kind of patents in the US, and in the other country they have different names, but it's sort of like a similar kind of a type.
Oh, thanks.
Sure.
Brian, shall we begin my portion?
Absolutely, perfect timing.
Thank you. Well, hello, everyone. Thank you so much for attending. This is very exciting for us. We really enjoy working with students and others. For each one of us, intellectual property is really goes into the heart of us, really. We love the area. We really enjoy working in it. And we want to welcome anyone who has any questions as future intellectual property practitioners, however way you do practice or however way you want to get into it. We'd love for you to contact us so that we can talk to you about it and discuss it. It's one of the fastest growing areas in all fields, whether it's engineering or science. So really want to hopefully through this presentation, we will pique your interest. My presentation is with permission from an attribution to Semron Trana, who is the Vice President of an organization called Innovation and Commercialization Office. And so a lot of this material comes from her presentation, and I just want to give her attribution here. Next slide, please. So I will pick up exactly where Dr. Chow left off and start talking about the differences between industry and academic innovation and commercialization. We want to make sure you understand how these two sides of commercialization differ from one another. Then I will talk about commercialization ecosystem within Indiana University, which really applies to any university, if you will. Then we'll talk about innovation and commercialization roadmap within Indiana University. And then I will just touch a little bit more upon career paths and intellectual property, which we've already talked about a little bit, but as a segue into the last section that talks about this very exciting program we have in IUPUI that provides the students with a fantastic opportunity to learn about intellectual property and put it into good use. Next slide, please. So what is the difference between corporations and universities? Well, corporations have established product lines. Some corporations have very broad established product lines. For example, Procter & Gamble. I mean, there are so many different product lines. It's incredible. Some other corporations have very limited product lines. For example, General Motors is in the business of manufacturing automobiles and trucks. They used to have a lot of other divisions, but nowadays they have reduced their product lines to automobiles and trucks. So if you, as an inventor within General Motors, you are going to submit a disclosure, your disclosures are going to be evaluated based on those established product lines. So for example, if a GM engineer invents a new skin cream, for example, GM will likely not be interested in that invention because it doesn't follow any of their established product lines. Of course, if that inventor was working for Procter & Gamble, they will be very interested in pursuing that. So, and also corporations typically have very large research and development budgets. I was looking at General Motors, they have a $6 billion research and development budget. They're in the business of automobiles and trucks. If you look at a company like Eli Lilly, they also had about $6 billion in research and development budgets for year 2020. Well, universities do not operate like that. In universities, there are no products. There are no established product lines. There are no products at all, in fact. Universities do not make things that you can buy and sell. In fact, each lab of each professor, which really amounts to hundreds and hundreds of labs within a university, in a sense, constitutes a different product line, right? Inventions then, therefore, as they are made, must be evaluated not based on a product line, but without regard to such a product line. So they have to be evaluated based on the merits of the invention, which is very difficult. You can imagine how much more difficult that is. And furthermore, universities by themselves do not have large research and development budgets. In fact, about 70 to 80% of commercialization offices, and what are those? Those are offices responsible for finding homes for these technologies that are developed within universities operate in the red, which means that they spend more money protecting the inventions and trying to commercialize those inventions than they bring into the university as far as revenue from those commercialization. But that's because a mission of a university commercialization office is to simply move a technology from the labs of the university to the hands of the public. That is a very profound mission statement for universities and university commercialization offices, but that is really their goal, is to move technology from the labs to the hands of the public. And when we say public, we really mean worldwide. Next slide, please. So this is a very busy chart, I know, but this really shows you the way efforts are expand within the university and touching outside entities in order to create this commercialization environment. So this is what I'm calling commercialization ecosystem within universities. Every university is going to have an IP policy, intellectual property policy. You can look up, you can Google, you can just simply Google Indiana University IP. As soon as you say IP, it's probably going to finish up saying IP policy for you. Every university has an IP policy, and basically that IP policy says that if you are using university resources, the invention that comes out of that work, if you're using university resources, belong to the university. Now, once that IP policy is brought in, you have the first point of contact called Office of Research Administration. Different universities call it differently. Here we call it Office of Research Administration. This office is the first line that deals with outside entities. So if a university professor has filed for a grant, let's say, with a funding agency such as NIH or NSF or any other funding agency, they have received funding through that agency, that funding agency first comes to the Office of Research Administration. If a corporation like Eden wants to work with Indiana University to generate some research and to do some work, they will first go through the Office of Research Administration. Once that contact is made and the dollars flow, then the dollars go to the individual departments that are tasked to perform either the work, for example, for hire, or the basic research that is tied to that grant from NIH or NSF. Once that research is done, then the inventors provide to the office, the Innovation Commercialization Office, ICO, a disclosure. Under this act called Bayh-Dole Act, which happened, and by the way, Dole, that's Senator Bob Dole, and Bayh is Senator Birch Bayh of Indiana, who has passed away, I believe, at this point. Maybe not, I'm not sure actually, but his son obviously was the governor of Indiana for a long number of years. But this Bayh-Dole Act was enacted in 1980, and it basically said if you get money from a funding agency, you are obligated to try to commercialize any invention that comes out of that research. So out of the ICO, we have, so once the disclosures go to the ICO, and I will talk about that in a few minutes, will decide whether they should protect, market, and license. Those licenses go back to either the corporate contract or the corporation that initially contracted, as you see on the left, or perhaps other interested corporations. And if there's no one, perhaps the professor that developed the technology would want to have a startup. And then on the right side, what you see is the dollars that come out of that licensing, those dollars will either go to, some will go to inventors, some will go to the IU departments, and some will go to the commercialization fund that allows this whole process to continue turning over and over again. So this is a great opportunity for inventors within a university. At the end of my presentation, you will see some amazing work that we have done at IU, and some of those inventors are now extremely wealthy because a third of what the university gets goes to those inventors. Next slide, please. So on the right, you will see the very, very first patent that was issued to Mr. Samuel Hopkins, signed by no other than President George Washington. Of course, nowadays our president does not sign patents. It's done by someone else. And then down below, you will see one of the more recent patents from a week ago, last Tuesday. And the reason I'm putting that up is that we're now at patent number almost 11 million. And by the way, for every patent that gets filed for, it's not a one-to-one correspondence that a patent gets issued. Each one of those patents that get filed, there may be one or two other patent applications that never get issued, but they all represent prior art against any new application that you file. So 11 million just patent references is a pretty big number. So patents are initially owned by inventors. And who is an inventor? Inventor is someone who has conceived of an idea and then has worked that idea into a particular implementation. That implementation has to be so concrete that it only takes a skilled artisan to take it from that stage to an actual prototype. It will only take a skilled person having ordinary skill in the art. That's all that would be required. That person becomes the inventor. Patents are initially owned by the inventors. Copyrights and trademarks, copyrights are owned by the authors unless the work was what we call work for hire, in which case the copyright goes to the company that hired the work to be done. We also have cell lines, these are different types of intellectual property, cell line, mouse models, antibodies, other things that come out of biological labs that are also considered as sources of intellectual property. Vis-a-vis the employment and enrollment contracts, individuals that use IU resources are obligated to assign their ownership to Indiana University, and that's how IU becomes the owner of the inventions of the intellectual property. Copyright ownership conditional on whether it's work for hire, so forth and so on, and whether significant use of university resources was done, whether it's a collective work, or whether it's a new textbook. Sometimes if a professor does a new textbook, university does not own that copyright. Next slide, please. So here's a chart that shows the expense and the amount of time that it takes to get a patent. There are different types of patent applications. You could have a provisional application. These will be utility only. Design patents do not have provisional patent applications. You could have non-provisionals that claim priority to those provisional applications or international. And then you can have national stage applications from those international patent applications. And here, just a sort of a general idea of what we're talking about. These are not dollars that necessarily go to a patent attorney, but cost associated for the university, overall cost associated with each one of these types of filings. So this is for one application. And this is just the patent filing. This does not represent the prosecution that my colleagues discussed about the examination process. You can pretty much take these and multiply them by 2 or 3 to get the total amount of cost associated from getting a patent filed from the first place all the way to issuance. Very long process and extremely expensive. Next slide, please. So I wanted to just go over the sort of the roadmap that we have here at IU, and Basically after the discovery is occurring and the intellectual property has been created as a creation of the inventor's mind, then you have to decide as the first step, do you want to actually protect that? The next step is you file an invention disclosure. Now there are off-ramps coming off of these this roadmap when you hit a snag and you realize that, well, this is not going very well. So there are off-ramps that we can take. But the first roadblock you get to is part of the green route on number 2. For example, if further development is needed, if you really are looking at a technology, but you have only developed a small portion of it and further development is needed, you may need to go back to stage 1. But you come out of 2 after the invention disclosure, and there is a triage whereby the technology is evaluated to see what sort of commercialization potential the technology has. Now, if the technology was created based on a contract with a corporation, there are typically contractual obligations that forces the commercialization to initially go back to the corporation that created the contract. But let's say if, so in that case, you would proceed to step 6, as you will see later. However, most cases, it's not going to be like that. And after the triage, when you're looking at the potential for commercialization, you go to the next phase. Next, please. So once the triage is complete, you create a commercialization plan. In this commercialization plan, you develop an intellectual strategy, intellectual property strategy. Where do you want to file? What do you want to file? Do we want to file utility patent applications? Do we want to file copyright trademarks? Do we want to file design patent applications? In what countries, in what regions? All of that will be sort of developed at this stage. And you also at the same time start thinking about what sort of customers are there for this technology, who might be interested in this, and then you begin developing a marketing strategy to be able to figure out how to go forward from this stage. If you can go back to, thank you. There is an off-ramp, I'm not sure if you can see that to the right, and this is where you realize, well, this is an unsustainable market. For example, if there's a market that either is very, very small or potentially it can only handle 1 year of sale, let's say, before the technology becomes obsolete, well, that informs a decision as to what to do. And you take an off-ramp and you say that this is the end of this technology and you move on to the next technology. Next slide, please. The next phase is marketing, and that's where you begin your marketing. You begin executing your marketing plan. You develop digital and or print advertisement to broadcast to a large number of recipients to show that this is a new technology coming out of Indiana University. We're very excited about it. It can do this, that, and that way people can see it and take action. If you have no interest, you determine that there is no marketing interest whatsoever, you can take an off-ramp and exit. From marketing, you go to the agreement and relationship, and that's where companies that might be interested will take a license from the university in order to practice the invention. Remember, a license is like a rental agreement. When you go rent a car, you don't buy the car, you just get permission to use it for a period of time for a certain amount of money. And that's what a license is. This office of commercialization prepares those agreements and establishes those relationships. And then we finally get to the product development and launch. And after that, revenue gets generated, and you've already seen how those revenues are dispersed between the university, inventors, and the commercialization fund. Next slide, please. So here are just an example of successful technologies that have come out of IU. Richard DeMarchi's company was acquired by Roche in 2010 for $250 million. Ali Jafari created the predecessor to Canvas, the technology that we use right now. And that company was sold for $80 million. So remember, Ali Jafari would get a third, or Richard DeMarchi would get a third of that amount divided by the number of inventors. So if there's 2 inventors, in the case of Ali, I know there were 2 inventors, they would get a third of 80 million divided by 2. So that's a lot of money to get from that commercialization. Awesome for inventors in the university. I don't think there are any corporations that would give that type of money to their inventors. Next slide, please. So I want to talk a little bit more about careers in intellectual property. As Jamal said, you can be an IP attorney. That requires you to go to law school. You can litigate, provide opinions. You can counsel, file with governmental agencies, all kinds of good stuff. Or you can become a patent agent. Here you don't have to go to law school. In fact, as soon as you graduate with a degree in mechanical engineering, electrical engineering, any one of the STEM type of degrees, you can simply take a single exam that is called the patent bar. And if you pass it, which is very difficult to pass, you become a patent agent. And you can begin doing some of those things that an IP attorney do, minus 1 or 2 very, very specific things that a patent agent cannot do. You can also become a patent engineer. Some corporations have these individuals that speak both languages. They can speak the language of legal protection as well as speak the language of the engineers. And so they become a liaison between the legal group and management. Or you can become a patent examiner. A lot of my students go and become patent examiners. They have incredibly good salaries. They start at 60,000 plus. The amazing thing is that after working from home for, working there at the office for 2 years, you can begin working from home for the remainder of your career. So majority of patent examiners work from home in that type of environment. Next slide, please. And then finally, I want to talk to you about this new intellectual property area that we have developed at IUPUI. It's very, very unique to IUPUI. No other place in the world has this type of program. And as you can see, the way intellectual property works, if you followed any of the roadmaps that I showed or Dr. Chow showed, what happens is the technology gets developed and then an invention disclosure gets submitted. Well, if there is a problem with intellectual property aspect of that technology, that is really the wrong way to go about it. That's too late to figure that out. So we have this program where we show and teach how to design according to a very structured approach. Students that take these courses come up with innovative design very quickly. They avoid infringing other people's intellectual property. They draft patent applications in the program and file those patent applications with the United States Patent and Trademark Office. So people that come out of these programs have 3 patent applications already to their names. Many already get issued patents before they even begin their career. It's a 3-course undergraduate sequence. And then we also have a single graduate level course as well. It's an exciting program. Will separate you from your peers, will cause IUPUI to be recognized as the first institution to offer such a program, and will provide you dividend throughout your career because you're really learning a completely different way of designing. You also can get a certificate that will appear on your transcript if you were to embark on this IP concentration. I think that's all I had. Yes, that's all I had.
Awesome,
How are
awesome.
we doing
Thank
on
you.
time, Brian?
No, you did a wonderful job, and we're doing good on time. So, do we have any questions for the academic side of it and the career options that have in this patent law space? Please use the raise your hand feature. All right, Mr. Nigel's back. I think Nigel's making a career choice tonight.
Sorry to disappoint you, Brian. I'm not. But my question is, because he covered a lot. So I want to go back a little bit. I think it was about when he was talking about the process, like first step, second step, third step, fourth step, that little map or whatever. Right, that. So I'm assuming that this coincides with the first two presenters, or is this a different?
Some parts of it are going to be very similar. Some parts of it are going to be very different. The first part is probably
okay. I'm sorry. Go ahead. I don't mean to cut you off. Go ahead.
The first part, the screen we're looking at right here, is going to be very similar, probably in a corporation. However, the triage aspect may be slightly different. The goals of the triage may be different in a university as compared to a corporation. In a university, again, what we're looking for, since there are no established product lines, that triage will be slightly different. Dr. Chow, would you agree?
Absolutely agree. I think this so like goes to the our discussion prior to this presentation is that in the corporate setting, I think the sort of this pass from the event discovery to the eventual sort of the commercialization is slightly different. It depends on in corporate usually it's a marketing driven kind of approach. We will find out what the customer wants, and then based on the customer needs, a customer needed solutions will sort of go back and drive the innovation. So it's a slightly different as in the university setting.
Did that answer your question,
Okay,
Nigel?
so I might have a couple questions on. Yeah, but it wasn't a 1-part question. It's like a 3 or 4-part question.
Sure,
So
sure. Go ahead.
If I were to present to you, like for example, if I were to present to you like with a company that recently went public, could you like basically like basically walk me through what steps you think they might have took based off of the company? Like if that
Sure.
kind of makes sense to you?
Right, and we had a much bigger presentation, and we had to trim it down quite a bit just because we weren't going to have all the time. But I did have one slide, and perhaps we can share that with the group here. One case that actually did go to sort of like an IPO, if you will, and the original disclosure was done in 1999, and just very recently it actually and I may have let me actually see if I can maybe bring it up and share. Do you know, Brian? Do you know if we can share our screen?
Yes, you can share your
Yes,
screen. I have it pulled up though, the other presentation, if you can tell me what slide it is.
It is slide 10.
Okay. Oh, I apologize. I've got the wrong one.
Well, it's my slide. Keep on going. I'll tell you where you
Okay.
get to it.
Okay. I apologize. We already trimmed these though.
I got it right here.
All right. Thank you.
Yeah. So let me just share my. Can I share my screen?
Yes, you should be able to.
Okay. Let's see here. Can you see my screen here? Nigel?
Yes, we can.
Okay, Nigel, this particular case, the invention disclosure came out in 1999, and then first patent application was filed in 2000. Then the first license was executed in 2002. First patent was issued in 2007. Sublicenses were executed in 2013, and FDA approval and product launch happened in 2018. So now this is a more of a pharmaceutical and therapeutic type of invention, and they typically take a lot longer because not only do you require patents to be granted and issued, you also need to have FDA approval. So that's a Food and Drug Administration approval of the drug. And that can usually take a lot longer than the patent issuance process. But here is an example of how long this process could take. But you know, this is probably a more lengthy process example. There are probably examples that will take 10 years, but it takes a long time. And that's the point. That's the takeaway from all of these presentations, that it takes a lot of sweat equity. It takes a long time, a tremendous amount of resources to commercialize a technology from an invention disclosure.
Yeah, I totally agree. Just want to add one comment. I think it's sort of like the patenting process and also the bringing the product to the marketing process can be sort of like it's in parallel, but the length can be significantly different. So the patent process itself, sometimes it probably take like from several months to several years. Depends on what kind of invention you wanted to get a patent on. But bring the product to the market always take a long time. Because you need to do all these kind of testing, like even Dr. Peluzzi just showed that pharmaceutical context, even in our electrical industry kind of a context, we also take several years in order to have a technology. Even if we during the internal review you consider that we probably will commercialize the product, but from that decision until the product actually comes into market, it will take several years at least.
Nigel, did that answer your question?
Yeah. So like, for example, that slide, that would be example, because obviously that's public knowledge and he was able to grab it. So, I mean, that would be an example of them not applying for a trade secret.
Right. So let's just be clear. When you have come up with a new invention, you have two paths in front of you. You can either go trade secret or you can go patent. You cannot do both because patent law requires that you have to disclose it. So if you have just as Dr. Chow showed, if you have a sort of an important invention or discovery or whatever that either is not patentable, because not everything is patentable, in fact, or something that you feel like is not very easily reverse engineered. It's okay to reverse engineer the Coca-Cola formula if you can do it legally. You're well within your rights to do that. So if your invention or your information is such that it's not easily reverse engineered, and you feel like patent law is not the right choice, you go trade secret way. But if you feel like you want to take advantage of that 20-year exclusivity, then you go with the patent law path.
Okay.
My question is, who does it belong to? Does it belong, let's say, to the staff person, student, or faculty member, or the university, or while they were at the university?
That's a very good question, Marie. And the answer is simply this. If you use university resources, the invention belongs to the university. If, however, you use your own resources, and then under certain very limited circumstances, you might be able to, for example, rent resources of the university, but you're still paying for that renting under very, very specialized circumstances, then you would own the technology yourself.
And only get the royalties myself then.
Right. Well, again, the amazing thing is that you get the inventive entity gets a third of the royalties, even if it is owned by the university, which is the big difference between universities and corporations. A third of it is a lot of money.
It's true.
I think there was another question and somebody, I don't know whether there was a chat question.
We actually have, there's actually a question in the chat box here. It says, how can students draw attention to technology that exists, but they have improved upon? Is it allowed for them to get those improvements or customizations patented?
Dr. Chow or Jamal, you guys want to take those, or you want me to answer it?
Yeah, I can take it. I think it definitely. I think it's if you see a technology and you design some kind of a improvement or have some idea to improve it, definitely. I think that improvement you can certainly try to get a patent on it. But the one caveat I just sort of get also related to the later we'll see the takeaways is that patents give you a right to exclude, not the right to do things. This is sort of a perfect example to show you that once you get a patent of the improvement of the existing technology, that doesn't necessarily mean you can implement the technology or build a product around it. It's more like if you need to see whether any kind of a patent will cover the underlying technology you improved upon. So getting that patent on the improvement doesn't necessarily mean you have the right to practice your improvement. You have to sort of like, do a sort of like a product clearance or, sort of like a freedom to operate kind of research as to whether the underlying technology is patented or not. So that's just, Jamal, you have anything else to add?
No, you covered that perfectly. Yeah, it's just so you have the right to prevent other people from doing that improvement. But if there was an underlying patent to the base structure and to the base technology, then you might not be able to actually practice your own patent because of that underlying patent on the base structure, on the base technology. So it's can be a complicated process, and if you wrap your head around the fact that it's the right to exclude and not the right to do, I think it starts to be a little bit clearer.
We have a few raised hands. Dr. Ruiz, what a combination of background you have as it pertains to this, being in STEM and being a lawyer yourself. So come on in and talk to us today.
You know what? I tell you, the kid in me is so excited. Deb knows that I've been talking to her for a long time about hosting this kind of session, and it's wonderful to see everyone here. I had a question. As we know, on a lot of our college campuses, there's really this focus on innovation and entrepreneurship. And if you are an entrepreneur and and not necessarily a student or in-house employee, how do you retain legal assistance? Is there free or low-cost help that individuals who consider themselves inventors can take advantage of? Obviously, we know in-house counsel works on behalf of the company, and then you may have outside counsel that helps, or other attorneys, but it can get pretty expensive. Is there any free or low-cost help for folks?
I can, Dr. Chow, did you want to say something?
No, you can go ahead. Go ahead. I'll just
I saw the mute sign go away. I can say a few words about that. I used to be connected to the law school, and I put together a law school clinic at the law school that is actually certified by the United States Patent and Trademark Office. So that's a very special program that some law schools have. So our law school actually has that clinic, and it's intended for individuals that cannot afford to obtain legal counsel in intellectual property, and they will help those individuals with the entire patenting process or trademarking process or copyright, which is more of a registration. So we do have a clinic at our law school that is intended for that purpose. My other answer is those students should really consider taking my classes, because the students that come out of my classes really have a very good idea of how to write a patent application and how to write claims that Jamal discussed at the end of that appear at the end of a patent, which really are everything with regards to a patent. I mean, claims are everything, right? Claims are examined for patentability, and claims are examined for infringement. So students coming out of my program get to really learn how to manage those claims and how to write patent applications that do well for them.
In addition to what Dr. Prosy just mentioned, I think certainly there's some help within the university, and also there's a U.S. Patent Office actually offer a patent pro bono program for independent inventors and small businesses. So if the inventors, individual inventors or small businesses meet a certain sort of a financial threshold and some other criteria, may be eligible for free legal assistance in preparing or filing a patent application. I can share the link with Deb after the meeting, and so that way Deb can circulate that with you guys if that will help.
Yep, and I'll also just add, there are also local mentoring services. I know our firm works with the Gateway Venture Mentoring Service here in St. Louis, and we provide pro bono assistance for that very fact for people who meet those certain criterias. We'll draft applications, help them doing various IP matters, for free. So I'm sure that there are similar services, wherever the individual may be in different locations. So I can share this one, but if you do a little bit of searching there's definitely going to be some similar programs at your disposal.
Thank you. We're in Milwaukee, so we'll have to get you gentlemen to Milwaukee for a session. Thank you so much.
No problem.
All right, looks like we have one more question, guys, and we'll get close to wrapping up here tonight. Mr. Nigel?
I promise it's my last one.
For now.
Right. I don't know if you can answer this, but I'm gonna ask it anyway. So like, let's say, because I don't know which line of defense it falls on, of like improving on an existing, or can it even be legal to even implement? So like, let's say if I was trying to implement a new technology, but it's similar to one that's already existing, but it's in a different field. So like, for example, let's say it may be structured kind of like how like Airbnb is, but it's in a different field but it's not Airbnb. So like, does that really count as a competitor at that point? Or, does it really, will it really get shut down because it's kind of similar? Is that like a too much similar type of legality issue or something?
Yeah, I can at least speak briefly to that. So, I think you've highlighted a pretty common rejection that happens when people are applying for patent application or applying for patents, because I work mainly within kind of a mechanical space, so there are not too many new mechanical structures out there. So when you have the construction of some piece that does something, it's probably going to look like something that's already out there. So what happens is it becomes the argument space, right? You have to prove that what you've done and within the space that you use it in, it is new and non-obvious enough to warrant an application, warrant being granted patent rights. So it really just becomes a question of, can you convince the patent examiner that the differences in the field and the way you use it warrant getting a patent. So you have to come up with evidence, but there's these new exciting results, and things like that that weren't considered or thought. And when you apply it in this space, it has this, transformative effect. So it becomes just an exercise in your argumentative and persuasive skills, and within the facts of why your invention in this new space should be granted a patent. So it is possible. It can become difficult though.
So I'll just supplement that by saying the following. There are really 3 requirements to get a patent. Your idea and the implement. First of all, an idea by itself is not patentable. It's the implementation of that idea that is patentable. Some implementations are just not, they do not belong to patentable subject matter. So first you gotta examine whether something belongs to patentable subject matter or not. But if it does, then you have to ask yourself, is my idea new? And when you're looking at newness, any field is fair game. If your idea was done in any field whatsoever, then it would be rejected on the basis of novelty. For example, the seminal case is someone came up with a way to dispense popcorn out of a funnel. So you have a cup that is filled with popcorn at the theater, and so you put a funnel on it with a hole, and then you shake it, and a few kernels of popcorn come out. Well, they rejected that on the basis of novelty. Why? Because there was a reference in an oil can dispensing where oil was coming out, something like that. And they said, because novelty can come from any field whatsoever, then that could be a novelty defeating reference. If it is not a novelty defeating reference, then the reference must come either from the same field of endeavor that you are applying for, or if it's not coming from the same field of endeavor, that it should be concerned with solving the same problem as you're trying to solve. Within that construct, you will have to argue that my idea is either new and that it is also non-obvious.
I've seen and heard about it.
How about when big companies go ahead and find an idea or something, and then they just take off with it? I'm sure that is very hard to prove, isn't it? That they, I don't know. But I have heard of one situation.
Brian, can you see my screen okay? All right, I'm just going to share it
there
again.
it goes. There it is.
Did you see it, Marie?
Yes.
Hang on one second. Why am I having such a hard time? All right. Brian. What the heck? Brian, are you there?
Yes, ma'am. Can you hear me?
Yes, I can hear you. I'm going to try to get back to our regularly scheduled program here.
Yeah,
and
I didn't see the screen there.
I know I'm struggling. There we go. Can you see it now?
Yes. All right. So we I don't know if we've mentioned this. I think we may have mentioned it on the call last night. But we have a wonderful summer internship opportunity. I didn't know, was one of the Eden personnel where you guys wanted to speak to this very briefly?
I can talk about it a little bit.
Yeah, let's give a little detail behind it.
Oh, sure. I sort of I think the one audience just asked a question. Do we want to address that, or is that just a comment? I maybe missed it.
No, just a comment. So,
okay.
So the students are being informed for the first time about this summer internship. We have where they can go. Deb will make sure that it's in the chat feature, etc. But I wanted to know if you wanted to just share a little bit more from your perspective of what the opportunity is.
Oh yeah, sure. So basically, I think this is the intern program. Basically, it's offers of positions for students to become an intern at our headquarters in Cleveland, Ohio. So they will be sort of directly working with the law team, and also as well as sort of with the engineering team to discuss the bio-humane disclosures. So I think we had I personally in the business because we have several IP councils. We cover different business units. So for the business I cover, at least I had an opportunity to meet one of the student interns. I think he was participating in the patent review meetings to get to the first hand knowledge. How the engineers give presentation on the invention, and then how the patent review committee reviews the invention, and sort of makes a decision, and also all that kind of pretty much the participation of the entire process within a company. It could be very helpful for the students if they not necessarily considering the career in the IP law area, but also even if they wanted to join the a kind of an engineering team, that will be also helpful, because nowadays it's pretty much a lot of companies have this kind of incentives for the engineer to invent, and but it's just not necessarily just you go into the lab and do some experiments, that's it. In order to generate a patentable idea, in order to draft the invention disclosure, provide as a summary, and also articulate the problems you solve, and illuminate the inventive points as compared to the prior art. All of that requires some kind of a experience or training. So that this is sort of a position will provide some at least some experience in that regard.
Awesome, awesome.
Mhm.
So I would like for all of our students to know that if you are interested, that's great. If you know someone that could be, able to take advantage of this opportunity, then please share this with them. I call this a wonderful friend. That would be pretty cool if I'm sitting at home and my friend sends me something like this. This lets me know they really care about me. And I'm telling you, Eaton's a very strong company. We have a strong partnership with Eaton, with LSMRCE. I can vouch with personal experience with the organization that they are a very credible and solid company. And you will be pleased to have had an internship with them. And it's just very unique that we're talking about, we're kind of getting into the niches of niches, right? So, and being a STEM student, we're already starting to get into a niche, right? And starting to find like, wow, there's no ends to this STEM life and this STEM career path. And so I just really want you guys to take advantage of it. Many people don't even know things like this exist until they're well in their careers. And so for you as a college student, to be exposed to this so early is really good. And you never know, you may not have had strong interest in this, and today may have, you may have a little bit now. I would say it doesn't hurt to try it out. You don't know if this is going to be your clear path to your future, but it doesn't hurt to take advantage of an opportunity and learn what you're interested in and what you're not interested in life. That's the importance of internships. So I really hope someone takes advantage. Dr. Ruiz, I wasn't sure. Did you want to say something before we progress there?
No, I think I have several of my students on. I know Nigel is one of them, very eager. I know that these opportunities don't come along, right, very often. So we want to get our students to participate. And to be honest, this is a very sophisticated area of law. And so if you can understand, if you're a STEM student and you can understand the law behind some of the functions that you perform, whether as a researcher on campus or when you get into industry or if you go to grad school, I think it's wonderful. And I appreciate Eaton and everyone here contributing to the conversation. I think it's just spectacular. And thank you to LSMRCE for hosting this.
Awesome. So here are a few resources that were provided. These will be in the chat feature for you as well. Please take advantage, do a little research, you get a chance to learn a bit more. And I'm pretty sure there's our guest tonight, if you have a question, pretty sure they wouldn't mind providing a response if you guys wanted to reach out to them. For our guest, if you would like to, you could please put your email address in the chat feature so the students are able to ask any questions that they may have. Next slide, please, Dan. All right, so just a few takeaways for tonight. Patent right is a right to exclude, not a right to do. File a patent application first before public disclosure to best preserve patent rights. Universities are different than corporations in terms of their goals and challenges insofar as IP protection. So this was really laid out tonight, I thought very, very well. And turning in a disclosure into a commercialized opportunity takes a long time, lots of sweat equity and a significant amount of resources. With that being said, one of the big takeaways I received from tonight is that you might want to get some lawyer friends. Yeah. You might want to have a lawyer friend or two. They have great value. All right, let's go to the next slide. So this is just really exciting to announce. So I think we did share last night. We are now preparing ourselves for our 10-week summer series. This is our second year of having our summer series. We're going to be tackling a large range of topics. We're going to dig deep into some challenging subjects. And then we're also going to be giving good information and education throughout the summer. We want to make sure you stay motivated and stay engaged. We do understand that there's still many students because internships opportunities are not as prevalent as they were when everything was on site. We know that there may be students who are still looking for things to engage in and stay active over the summer. One challenge that I send out to you is make sure that you invite a friend and you ask them to come be a part of this as well. All right, if you have any questions, you guys know, always you could reach out to me and Deb. And just want to say thank you to all of our collaborators so far. We've made it through our spring session, getting ready for the summer, and then slowly we'll start piecing together better and more informative sessions for you in the fall as well. So I just want to say thank you. And then I'd like each guest, we'll go right to left here, start with Mr. Jordan. Let's give the students a little going off message here.
All right. Again, thanks for having me. I enjoyed it. There's some great questions. Hopefully we answered those and can help you to understand the topics a little bit better. I'll just say, I think being in STEM is great. I started off, I was a biomedical engineer, and I found the path of law. So I just encourage everyone to continue on this path. There's a lot of different ways you can go with a technical background, and so you're on the right track.
Thank you for having me. I really enjoyed the session. A lot of great questions from the audience. I'm happy to answer them. And if you guys have more questions, feel free to email me. I shared that in the chat. Like Jamal, I was in the STEM field before I became a lawyer. So I was in electrical engineering for several years before I decided to go to law school. So I think that you guys, definitely STEM area, there's so many choices you can choose from, not necessarily just like you have to become a certain career just because you study STEM. So just work hard, and you'll have a lot of opportunities in the future.
I would just like to say thank you everyone for the opportunity to be here. And my message is never stop learning. Learn all the way until the last breath you take. That's all.
That's a very short yet powerful way to end the session tonight. Thank you for those words. Thank you all for sacrificing your time to come and educate our students tonight. And students, thank you for taking time out of your day to get educated. So without anything else, have a great night, and we look forward to seeing you later in the month of May as we kick off our 10-week summer series. Take care, everyone.